welcome to this human rights conversation tonight. Welcome here in the Villa Monnier in Geneva, and welcome to all of you who are joining us online. My name is Felix Kirchmeier. I'm directing the Geneva Human Rights Platform, and I'm your moderator for the next hour and a half. Please note that this event is recorded. It's hybrid here in the room and online, so it's a public event which is being recorded. For those online, you can later also send comments and questions in the chat, but also in the setting that we have, you can take the floor directly in the discussion later on. Please, until then, keep your microphones switched off, but switch your cameras on if you wish to, so we also see you on the big screen where you'll be shown once you take the floor later on. Human rights conversations here at the Geneva Academy are a series of events hosted by the Geneva Human Rights Platform aimed at discussing contemporary issues and challenges related to the promotion and protection of human rights. Taking place, those discussions in Geneva and beyond. Today's topic is the domestic institutionalization of human rights. This is a special event in the series in as far as we team up with an excellent and long-standing partner, the Danish Institute for Human Rights, where the editors of the book that we will be discussing today are being based at. It is also special in that we have the pleasure today here to have the Geneva launch of this book. I'm showing it also, yes, I think you can see it on the screens as well. The Geneva launch of this excellent publication, to which also my colleague Domenico Zipoli, who joins us here on the podium, has contributed an interesting chapter. The new book, The Domestic Institutionalization of Human Rights, edited by Stéphanie Lagoutte, Sébastien Lorient, and Stephen Jensen, and published by Routledge just in September of this year, explores recent developments pointing towards the domestic institutionalization of human rights, outlining ideal models for national human rights systems. As such, I may say it is a perfect preparation for the upcoming annual conference of the Geneva Human Rights Platform on 12 October, which will be dedicated to the interaction of national human rights actors and the Geneva-based UN human rights system. Today we have with us on the panel here in the room and online very distinguished speakers, and I'm happy to announce them and introduce them as we go along in the event. We have with us online Stéphanie Lagoutte, who is the senior researcher at the Danish Institute for Human Rights and a co-editor of the book. We have, to my left, Sébastien Lorient, senior advisor at the Danish Institute for Human Rights, who made the trip to Geneva. We have also, to my far left, Domenico Zipoli, research fellow here at the Geneva Academy and working with me in the Geneva Human Rights Platform. And as a commentator also, we are very happy to welcome Bertrand Ramcharan, former UN Acting and Deputy High Commissioner for Human Rights, to my immediate left. And also, again, online, Nosy Ramamojisoa, former Secretary of the Committee on Economic, Social and Cultural Rights, and now coordinator of the Treaty Body Capacity Building Program. Gabriela Haptom, Secretary of the Human Rights Committee, who was supposed to be with us, had just informed us this afternoon of an emergency that prevents her from coming here tonight. She might actually still join us online, so we will see later whether she will be commenting as well. Now, before handing the floor to the panelists, a final promotional. We have no books here for sale. But again, many of you are online, so that doesn't touch you much. But we do have a discount voucher, both printed here in the room, but also posted online with the announcement of the event, which you can use if you want to purchase this excellent publication. And with this, let me turn directly to Stéphanie Lagoutte, co-editor, as I mentioned, of the book. And Stéphanie, very nice to have you with us online today. In your chapter, you focus on state actors, but I think it will be excellent to hear from you also a little bit more about the genesis of this book, which I understand is also indirectly an outcome of a meeting at the 2018 conference of the Associations of Human Rights Institutions, an association to which both our institutes are affiliated. So with this, Stéphanie, over to you.
Yes, good evening, everyone, and thank you, Felix. So I'm just checking with you that you can hear me properly. Yes, yes. Okay, thank you. Yes, well, I'm very happy to participate to this book launch, even if only online from Copenhagen. I want to start by thanking the Geneva Academy and especially Domenico Zipoli for setting up this event. Thank you very much. Yes, well, our book that we are launching today at the Geneva Academy is the result of a rather focused and sequenced and participatory endeavor that started when myself, joined by Sébastien Lorion, who's with you, who was doing his PhD with me at the Danish Institute for Human Rights for some years. It started then when we set up a research program that aimed at looking into the role played by state actors in human rights implementation. And I must say the inspiration for this research initiative was to be found both in the international project work of the Danish Institute for Human Rights, so in our practical work that we've done for almost 20 years now, maybe 25 years actually. So both in this practical work and also in the theoretical and normative developments during the same period of time that took place, and that we're aiming at understanding and also strengthening human rights implementation at domestic level. So we have the book really has both a practical leg to stand on and a more theoretical normative one. Along the way, you mentioned the ARI conference where we all met some years ago, but along the way we met and gathered young and more senior researchers, and some of them are present today around this project, as well as around other projects that were peripheral to this one. But for example, the latest one has been sort of a sequel of this book, which is a project on governmental human rights focal points, which findings we have published very recently with the Netherlands Quarterly of Human Rights. So with all these projects, we really tried to give room to researchers and context and approaches that we were not very familiar with to start with, and we think it's been, it's been enriching our own work quite a bit. And in this respect, I want to thank right away the contributors to the book for their participation and also for the rich exchanges we've had on each other's text. And I also will have a special mention for our co-editor and colleague Steven Jensen, who's not in Geneva, who brought his open-mindedness and his very amazing academic quality to the project. So that was, we were 3 editors doing that. And I want to add too that it's a real pleasure to be presenting the book with Sébastien and Domenico, who have both contributed to the book, as you mentioned, Felix. Also during the time where we were developing the book, they've both also successfully defended their PhDs, which both actually contribute in rather different but powerful ways to our research agenda. So it's very nice to have you here. And while we're here, I also use the opportunity to acknowledge their tremendous energy to carry on with this work, both academically and also supporting the work of practitioners and state actors, both with the Danish Institute and the Geneva Academy, and in cooperation with each other. So thank you very much. But so the book that we are launching today explores, recent and now a bit less recent developments in the domestic institutionalization of human rights. So this normative and practical trend that we call domestic institutionalization of human rights has been promoting the setting up of domestic institution and coordination to ensure better protection and promotion of human rights at domestic level. So to be clear, it includes very much human rights governance actors, such as national human rights institutions and governmental human rights focal points, as well as coordination processes and coordination instruments, you could say, such as national action plans, national human rights action plans. But this trend also includes more traditional human rights implementation actors such as parliament, and especially through the promotion of the establishment of parliamentary human rights committees. So we are dealing with a variety of actors, looking at this general trend of promoting this institution. Clearly, these developments, they represent a response to bridging the implementation gap that everybody, a lot of scholars have been writing about, between human rights commitment, the state human rights commitment, and the reality on the ground. So we hope the book can be a step to analyze the international community's ambition to build strong and sustainable state institutions that protect human rights as well as contribute to social change. So we try to keep both this duty bearer approach and right holders approach, hoping supporting social change in domestic context. The book introduction captures these developments that I've just mentioned, their main element and the key challenge and points of debate. It also tries to show that this trend is also asking or inspiring a new or renewed attention to the importance of national level institutions within international human rights regime, and particularly revisiting the roles of state actors at domestic level. So for us, it's clearly a move to the domestic level, so a bit more away from the Geneva machinery, but trying to see, okay, how is this synergy and interaction playing in at domestic level. The author's contributions to this volume, they explore the domestic institutionalization of human rights, taking as a point of departure the UN attempt to frame this phenomenon under the concept of national human rights protection system in 2002. And for this reason, it's a tremendous honor that Mr. Bertrand Ramcharan has accepted to give comments on our book, as he was at the origin of promoting the concept of national human rights protection system in the UN, and is also duly quoted in the first chapter of the book in my chapter, which focuses exactly on the role of state actors within the national human rights system. Maybe I could say briefly that this first chapter explores the conceptual underpinning of a systemic approach to domestic human rights protection. So some of you would know a lot about that because part of the PhDs I were mentioning before were also building on this. But the idea is that the attribute of a systemic approach to domestic human rights protection are the following. I mean, first, we're dealing with normative, performative, and generic system. So it is a larger approach than looking directly at the context. A systemic approach also is an approach that looks into a collection of components which have a common purpose, and in our case, it's the protection of human rights. It also, a systemic approach also includes structures, functions, interactions, capacities. So that's elements we are looking into. And of course, a systemic approach looks at, looks at a given context, but in relation with other systems. So a system is always in relation with other system or operates with other systems. So it's just to say that that's the systemic approach which was at the core of our overall approach for the book. In the case of the first chapter, the idea was really to embrace both the vertical dimension of domestic institutionalization, so a prescription from the UN trying to promote a model, and the horizontal dimension inherent to the concept of national human rights system, what is going on at the domestic level. And the chapter looks particularly in three elements that we think are very important and that probably Mr. Ramcharan will recognize: the coordination of state actors at domestic level, the interplay between state actors and non-state actors, and their interactions with international human rights mechanisms. So the last part being the vertical dimension. And that's what the contributions to the book also look into. They present various models and cases which highlight first, the specific forms of institutions being promoted it also highlights their intended interaction at domestic level, and it looks into how these institutions are strengthened by international treaty bodies or international bodies in general. So yeah, so that's for the overall presentation of the contribution. Very briefly on the contribution to the book. Maybe I just wanted to share my screen just a second, because I wanted to show you exactly what we have here. So I'm not sure. Yes, I think you can see what's in the book. So the first, so I mentioned the introduction and the first chapter. I just want very briefly, I can't go through the contribution themselves, but I can just mention that the contribution by Kirsten Roberts-Lyle investigates the role and potential of parliaments in improving implementation of international implementation of international human rights standards. So her analysis starts looking into the OHCHR 2018 draft principles on parliaments and human rights, which prescribe the establishment of the parliamentary human rights committees I was mentioning in the introduction. And she goes on looking at both the question of the direct parliamentary engagement at the international level, so again, this vertical dimension, and the risk inherent to creating new focal points at domestic level. So that's the horizontal dimension, so creating new human rights focal points at domestic level. Then the contribution by Claire Medvin O'Brien and Julian Ford examines how the business and human rights field, despite its intrinsically transnational and multi-actors character and also multi-layered character, how this field is still relying on and contributing to the evolution and ongoing evolution of national level protection systems. So she's also they're also looking at a specific thematic field. Sébastien Lorient's contribution is at the heart of the new governance approach to national human rights implementation and systems design. I just mentioned that the case in point here is the CRPD Article 33 on national implementation and monitoring, and I think he will talk a bit more about it. But really, this chapter shows how new governance principles are spilling over into human rights law. Finally, the last two articles, they focus on NHRIs, which is also at the heart of national human rights systems. Domenico Zipoli focuses on the vertical dimension of the system approach and the measurement of the effectiveness of the interaction between the UN treaty bodies and national human rights institutions. So it's also the main topic of his PhD. And finally, Tomer Brood and Nathan Milikowski looks into a different setting. They look into the risk and opportunities concerning the establishment of an NHRI in Israel. And what they focus on is the fact that, as it appears that several functions of an NHRI are already covered by several actors of the national human rights system in Israel. They look at how to reinforce the human rights mandate of the relevant actors if it's not possible to establish an NHRI. So again, it's another way of looking at mandates of actors. Maybe to conclude, because I don't have so much time left. Of course, we hope that our book can be part of a larger discussion. And as I mentioned in the introduction, we are already trying to further the discussion on specific actors of the national human rights system with the new, with the supporting and ourselves carrying new research. But it's also important to us that some of the findings that emanate from our research agenda can inform also practical human rights implementation project work, such as the one we're doing at the Danish Institute for Human Rights. I mean, based on our findings and based on our experience also working with international projects, we try to argue that a systemic approach to international human rights work gives results in a variety of contexts that help to for instance, find several entry points in one given context and pooling resources and expertise when it's possible. So it's a way of accessing several entry points depending on the context. It also helps to develop the capacity of several actors at the same time, which is also very useful for supporting mechanism of coordination and so on. And also it tables in a way on the complementarity between various compliance implementation approaches and designs to try to ensure better human rights protection. And of course, very closely linked to this, we also would like our findings to inform the strategical priorities of international organizations and international donors working with human rights implementation and capacity development of state actors in context. And last but not least, we also wish with this work to question and open a debate on what we see as a deliberate attempt by international protection systems or mechanisms like the UN to situate some specific actors and to situate also soft governance at the core of new compliance strategies. And we find that this is appealing in many ways. It's a pragmatic choice, and it's also it's also an approach that is measurable and has a lot of advantages. But we also ask the question whether this approach is actually supporting implementation and protection of human rights in practice, or whether it's doing something else, just strengthening institutions. So that's one of our main concerns that we hope they will be able to carry on in future research. That was for my introduction. I think I've used a bit more of my time, but thank you for giving me the word.
Thank you very much, Stephanie, for walking us through the publication, the thinking behind it, the contributors, and indeed, I would like to pick up on your keyword of synergy, the synergy within the national systems that you speak about, and of course also the synergy between the national actors and the international, and well, the relationship vice versa. And that is, I think, leading over nicely to our next speaker, to Sébastien Lorient, your co-editor on the book, who contributed in his chapter also to the discussion the example of CRPD. You mentioned that, Stephanie, already, the Convention on the Rights of Persons with Disability, setting up an international convention text, the creation of national monitoring mechanisms. So, Sébastien, what can you tell us about the success of this very link, of this very direct link, actually, that we see in CRPD? And Stephanie mentioned it's a novel approach. How would you see that also transcending maybe towards more treaty bodies, more use that system? So we'll be keen to learn from your experiences. Over to you.
Yes, thanks for the question. Maybe I'll address some of them in the also in the discussion. And it's really great to be here with so many people online and present. Thanks for organizing this, Felix, and thanks for amazing co-panelists and the two commentators. What I thought I would be doing very briefly is to walk through the chapter 4 of the book, which is the one I contributed, and to use it as an example of why we think this agenda, research agenda, is important, and maybe on the way I will answer some of your questions after that. So the chapter really focuses on the importance of the 2006 Convention on the Rights of Persons with Disabilities, CRPD, in the process of this domestic institutionalization of human rights. And I believe that the CRPD and the literature around it by renowned scholars shows how different ideal models for national human rights systems can be promoted, and how they actually influence state practice, but also potentially the future of human rights. And so in this presentation, I'd like to make 3 main points. The first one is that the CRPD is a catalytic moment in the institutionalization processes. You're well aware of that. I think I will just quickly set the scene. It's together with the 2002 optional protocol on the Convention Against Torture, which requires national prevention mechanisms. It's the first treaty that actually provides not only obligations of results, right, but also obligation of conducts, and sets in very detailed way how the states should organize themselves in order to implement rights. So at the core of this, there is Article 33 on national implementation and monitoring, which foresees that the states should appoint or establish focal points within governments and coordination mechanisms within governments to implement the convention, NHRIs and other independent monitoring bodies to protect, promote, and monitor the implementation, and ensure the participation of persons with disabilities and their representatives in monitoring. And in fact, participation is both a standard and a procedural attribute of many rights in the convention. There are also a dedicated article, which is also new in the Human Rights Treaty, about data collection, and many procedural obligations that are attached to the different rights. So it's very much about the ways states should implement rights, which is at the core of this convention. The second main point of my presentation is that although this is all unprecedented because it's the first time that it's legally binding in a treaty, it is yet important and useful to see the CRPD in a wider continuum of initiatives prescribing state features through UN guidance, soft law, international state conferences, and so on. And if we take this wider approach, then we can see the different contributions that are being made over time. And it also shows some nuances that appears when a guidance is produced, for example, by the UPR or treaty bodies. So sometimes you have these different elements that contribute to the institutionalization process, but are not exactly completely aligned. And so we think that by looking at them collectively in this agenda of domestic institutionalization, it helps looking at these nuances and review these changes. So there are different elements in the system. One is NHRIs. Here it's very easy to trace how the guidance has been evolving over time because you have various principles. NHRIs are well conceptualized, but in the article you still see in the chapter, you still see how the UN, the CRPD committee has been adding new elements to the conceptualization of human rights. I've reviewed the 55 first concluding observations of the committee, and it shows that there's a strong insistence on independence, but a lot less on other aspects of the NHRIs, for example, the protective mandates that they have to carry out in the independent frameworks under the CRPD. What is maybe more interesting but more difficult to perceive is the governmental part. And actually, as Stephanie said, we have a new project on that, and I have some copies also of another book that I can show you later on. There's been a lot of different initiatives coming from the field of gender equality, the Beijing conference, for example, the CRPD, and more lately the NMRX initiative by the OHCHR, which look at similar issues, but somehow are, because they have different names or they emanate from different bodies, they don't necessarily see each other as relying or being part of this genealogy of guidance that touch about governmental structures. So we think that by looking at them together, it better informs new initiatives to see how they actually build on past experiences. And so just to take one example that is in the chapter and just limited to the field of disability rights, you can observe that, for example, the notion of the governmental coordination committee has been evolving in the guidance. So before the CRPD, you had soft law, UN standards that were not part of treaties that asked states to set up coordination mechanisms that involve ministries and persons with disabilities. Whereas the convention itself, because also of compromises during the negotiation, asked states to set up coordination mechanisms within governments. So there was this little but very important difference, which was then settled more recently in the General Comment 7 of the CRBT committee, to say that, in fact, this should be hybrid committees involving both ministries and rights holders. But in fact, this, for example, is still a debated point, because you have all other scholars that have looked at the CRPD and says, yes, it's fine that there are rights holders and governments, but what about service providers, for example, that are supposed to help the state deliver on rights? And there's been this reliance on new governance theory, which is at the heart of my chapter, which is also coming in to recommend specific ways of building state structures. So, for example, from a new governance perspective, it is better to have all parties involved, even the service providers, in order to co-produce public policies and lead to better implementation collectively of these policies. But of course, this is an idea that might be less appealing to disability rights organizations, which saw these structures in ways to ensure participation in decision making. And this leads to my third point, which is actually at the heart of the chapter, which is to show some of the assumptions that are carried out in the different ideal models for national systems and for state features. As I said, the guidance sometimes just emanates from compromises during state negotiations of treaties. The OHCHR is producing guidance, but within the remit of its own mandate. Treaty bodies have their own quest for legitimacy, so they might shy away from being too prescriptive of state structures and so on. But I argue that there's also an element of belief in which governance structures are the best equipped to deliver on human rights, and more generally, which organizations of states are better suited to deliver on public policies. And so, in the if you look at public administration theories, at some points it was more fashionable to have privatization, and now you have a bigger accent on new governance, which tries to make sure that citizens are involved in decision-making processes and in implementation. And the chapter tries to show how there's a new trend in international legal scholarship that is what I call new governance legal scholarship, which is embracing these theories as a way to promote new ways of implementing human rights. One prime example is the recent publications by Professor Raina de Burca, which uses actually the CRPD to build a national human rights systems embedded in the international systems, which she calls an experimentalist regime. And in this theory, you construct a sort of iterative process by which the treaties are actually not very strict in terms of normal normal strength and precision, but only set broad goals. But what's important is that then you have national structures which can spell out through consultations and participatory planning the actual content of rights in context, and can then experiment these public policies and then feedback this to the treaty bodies or the conference of state parties. So there's this idea that we can build a system that would sort of incrementally and iteratively build the norms. So all that to say, you can read about that more in the chapter. Actually, there are copies for those who are in the room right here that you can take. But the idea is to show how you can build different ideas of national human rights systems and why it's important. In fact, this new approach angle, I think it's far from anecdotal, because now there are proposals for the new Business and Human Rights Treaty, for example, which would legalize this approach and look at structures rather than norms. And I think this is very important for the future of human rights, and it also invites us to revisit what we do with other compliance theories, such as litigation and the use of courts. And yeah, I think it's an example of why it's important to look at this these institutionalization processes, the scholarship that is associated with it, and what we've been trying to do in this book and in subsequent research projects. Thank you so much.
Thank you very much, Sebastian. And indeed, it's interesting to see that you analyze both the trends in the COPs, the computing observations, but also the academic trends, and really bring together that mix of the empirical observation of what the system is delivering and also the developments that we have in the academic debate. So thank you very much for the presentation and obviously your article, your chapter. And let me turn to our third panelist now, Domenico Zipoli, a colleague here at the Geneva Academy. Domenico, your chapter portrays the engagement between treaty bodies and NHRIs, but I think there is, for the NHRIs, we have the Paris principles well established, as mentioned, I think also already in the introduction by Stephanie. What do we have in the larger sense for national human rights systems? Where does all that go? So please, over to you.
Thank you, Felix, and good evening to all of you, both in the room, and what a pleasure it is to finally have people here at Villa Monnier and both online. Before I start, I would firstly wish to thank both Stephanie and Sebastian, as well as Stephen Jensen, who I believe has joined us as well, for their great editing efforts towards the book. The research agenda that we have been developing on domestic institutionalization of human rights has by now its own history, and it has indeed been a great pleasure to collaborate with you since well, my beautiful years at the Norwegian Center for Human Rights at the University of Oslo. As Felix mentioned, my contribution to the book consists in an effectiveness analysis of one specific interaction between the international and the national human rights systems, namely national human rights institutions' engagement with the UN Human Rights Treaty Body system. The chapter, in a way, is a sort of condensed version of the broader body of work that made part of my PhD, and I, of course, invite you all to read this chapter, those of you who are interested in the work of NHRIs, which is perhaps a lighter read than the 400-odd pages that made the PhD thesis, and not all of us were that lucky, as Stephanie can testify, I believe. Unfortunately for her, and luckily for me, Stephanie has had to go through the whole thesis as part of the adjudication committee. So a double public thank you to you, Stephanie, for that. So this evening, I will take the opportunity to briefly touch upon a different, broader, and perhaps more forward-looking aspect than that covered in my chapter. As discussed in the earlier presentations and throughout the book, the past decade has witnessed an increased involvement of different national human rights actors in accessing the international human rights system. And in turn, of course, monitoring the implementation of the recommendations stemming from the different bodies. And NHRIs, which of course are the subject matter of my chapter, are just one of the many national human rights actors who are now actively engaging with the international human rights systems, with national mechanisms for reporting and follow-up, governmental human rights focal points, national monitoring mechanisms, national preventive mechanisms, SDG focal points, ombudsman offices, national statistical offices, parliaments, CSOs, and networks of CSOs, city council, as well as the private sector, and these are just a few mentioned, have all been ramping up their monitoring and implementation efforts, often in coordination with each other. And it seems timely for us, therefore, to explore the potential for more consolidated national human rights systems, aimed at rationalizing, in a way, the monitoring, the implementation, and follow-up of recommendations emanating from the UN human rights system. So within such understanding of rationalization, it is important, first of all, to map all the relevant actors and determine the obstacles as well as good practices that guide the process towards a consolidated national human rights system. Such a mapping exercise represents a useful first step, in my view, in order to reduce the workload of national actors and the duplication in reporting to UN human rights bodies through a common monitoring methodology. Both our book and the UPR Best Practices report published by Milun Kotari and presented this very afternoon during a dedicated Human Rights Council side event are examples of such mapping initiatives. What is still lacking, however, today is international guidance on how domestic institutionalization and related institutional collaboration at the national level should take place holistically, so taking into consideration the broader network of actors that I've mentioned earlier on. In other words, it might be worth exploring the possibility of initiating a multi-stakeholder process that leads to a standardized set of principles for effective national human rights systems. This would require developing a series of guidelines towards more consolidated national systems, taking stock of different national stakeholders' role in the implementation, monitoring, and follow-up, but as well the interaction that these actors have amongst each other. As we mentioned throughout today's event, there are a number of principles that are currently available, which relate either to the overall functioning of specific institutions or the modalities of engagement between specific sets of institutions. Notable examples include the Paris Principles and the general observations of the Subcommittee on Accreditation of the GANRI, the Belgrade Principles that deal with the relationship between NHRIs and Parliament, the not very well known but very much present CANDI program of action on the cooperation between NHRIs and NGOs, and the CANDI Plus program of action, which is an updated version of that, and the more recent Pacific Principles of Practice on national mechanisms for implementation, reporting, and follow-up. Also useful for this exercise are the various treaty body specific papers that deal with the treaty body engagement vis-a-vis different national human rights actors, so NHRIs, parliaments, and CSOs. The OHCHR, and I'm happy to see some representatives present in the room as well as online, of course, on domestic stakeholder engagement would also be a useful set of instruments to draw inspiration from. So in light of the above list and pre-existing guidelines and principles, the idea that could be proposed is that to start thinking of a series of overarching draft principles that are relevant for the effective functioning of all national human rights systems, so taking into consideration the different actors, both state, non-state, and independent state actors. This process would firstly require the identification of the different roles that specific human rights actors play in the broader national system. Our book does a bit of that work. The report by Milun Kotari has also gone to great lengths towards that. But then on this basis, it would then be possible to determine a number of guiding principles, including specific sections on broad characteristics. And just to get our mind going and for further inspiration, such broad characteristics may include topics such as institutional design, effective interactions among national human rights actors, meaningful participation of all relevant stakeholders, transparency and accountability, of course, in the decision-making process, availability of resources, accessibility, and digitalization. So yes, in conclusion, if we are to better integrate international human rights law and policy in the day-to-day workings of the realities on the ground of the different actors out there, an answer could be found by looking, of course, at the connectivity between the international and national human rights system. And this, in turn, to my mind, requires a more thorough and systematic understanding and guidance, and this is where the idea of the principles comes from, on domestic institutionalization processes worldwide. So in a way, a standardized set of principles for effective national human rights systems could be a useful step in this direction. So this is all for me. It'd be very useful to hear your thoughts, of course, on both the book and on this possible initiative. And well, I look forward to the discussion.
Thank you very much, Domenico. Thank you for setting the scope for the next book and also for what could be a promising international process. So we'll discuss that as we open the floor. Before doing so, I will first turn to the two colleagues who have accepted to be our commentators on the book chapters, but also on the ideas more broadly. And I will start here in the room first with Bertrand Ramcharan. Sorry? Let us go that way, because I think as a colleague from OHCHR just accepted to jump in a very late announcement. So I'm starting with you. And well, as also Stephanie said before, you reportedly invented the concept of national human rights systems. So it will be great to hear from you how you see this coming along since your time as acting High Commissioner, and what your take is on the promising side of the national systems, of the national engagement, where that can take us. So I'll hand the floor over for your comments.
Well, thank you very much, Felix. I just wanted to make a gesture to my colleague from OHCHR and give her the floor first. Young people, the philosopher Heraclitus wrote long before Plato, you can never step into the same river twice. I have stepped into my river, and now I'm stepping into your river. And so I come to this book, first of all, with respect. I come to it, I have learned a lot, and I'm asking myself, what might I say to you that might possibly be of some assistance? And if I think about it, I think that when the Universal Declaration of Human Rights was adopted, immediately, I think, shortly after that, there was a resolution of the then Commission on Human Rights. Was mine? I don't know who. I think the Lord is calling me. I cannot believe. Oh, sorry. Forgive me for that. Yeah, and when the Universal Declaration was adopted, there was a resolution on the importance of national institutions. If you think about it, the idea of establishing international norms that are binding upon states is that governments should make good faith efforts to implement these norms. And the bottom line is that it's either, I'm very sorry, you have to excuse me, this doesn't come from my time. Mike, I'm giving a lecture and everybody thinks that I'm a good guy. Yeah, call him back. Actually, for those of you who are here from the Office of the High Commissioner, who's here from the Office of the High Commissioner? Yeah. This is a former colleague from Human Rights. Her name is Michael Nolwagen for the German. And so anyhow, yeah, so the idea is that states must comply with their obligations strictly. And I noticed, focusing on the book, that one of you at some point in time, you are speaking about contestations on the universality of human rights. And you're speaking about democracy. And I want to alert you that Freedom House has published a report earlier this year that the number of democracies in the world are visibly on the decline. So I want to invite you to begin with to consider that when you look at this area of national efforts, when you look at the methods that you're looking at, please keep in mind this issue that governments have an obligation to apply and to comply with their international human rights norms. And it's either they do or they do not. The first thematic mechanism established in the United Nations was a working group on disappearances. And I'm not trying to impress, but I wrote the resolution that established this. And so I looked at the report of the working group last evening. Then you see the statistics of the number of people made to disappear. You see the comments of the working group on disappearances in different countries. So I want to ask you, please keep in mind that there is this issue of gross violations of human rights within countries. Having said that, I would ask you to keep in mind three concepts: the concept of promotion, the context of protection, and the concept of prevention. Secretary General Annan at one stage, in one of his reports on preventive diplomacy. He called for the establishment of national prevention systems vis-a-vis conflict. But this idea of prevention is very important. Felix, you will tell me when I'm near the tree, so I will. I want to say to the authors of the book the following: you are discussing national human rights systems, and it's a concept. This is the valid concept. In the work that I did, I placed the emphasis on national human rights protection systems, and I don't put the two in opposition, but I think that they are both valid concepts. And but I ask you to keep in mind these two concepts. And Domenico, in your chapter, you were speaking about goals-based approaches. I want to flag this issue of goals-based approaches. At the end of the day, whatever you do must be designed to promote the implementation of human rights, and it's either being implemented or it's not. So that's the bottom line. Then I want to say this: the chapter on Parliamentary Human Rights Committee. I support the idea of Parliamentary Human Rights Committee. And years ago, young people, I would invite you to go and look into the literature. A guy named John Salzberg. John Salzberg was the assistant to US Congressman Fraser, and they pioneered this whole area of congressional and parliamentary approaches. And John Salzberg has written in the literature about the roles of parliamentarians. Then now, I noticed that Sebastian, you're speaking about litigation-reliant approaches. But at the end of the day, in my concept of the national protection system, you're asking 6 questions. Is your constitution reflective of international human rights? Is your legislation reflective of those rights? Are the courts able to apply these rights? Are you teaching the rights? Do you have specialized institutions like a national human rights system? And do you have arrangements to detect problems before they break out? Yes, so now this, the role of courts. I think it's as important because at the end of the day, you get a lot. Melon, may I say this? I followed your program today. I respect your study. I bow down to you. It's a great study. And I bow down to everybody who spoke. And I'm saying to myself, a lot of this stuff is a bit in the air. Because you see, these very governments, there are some governments that spoke there today that I would not give 2 cents for. And they're talking about, anyway, and I leave it aside. So you see, for young people from OHCHR, there was Theo van Boven was the head of the Human Rights Division. And when he got fired, basically, he gave an interview in one of the Swiss papers, and he said, "Quand on s'occupe des droits de l'homme, il faut envisager des ennuis." So if you're dealing with human rights, you have to be ready to take some risks and whatnot. I noticed that there are 114 national human rights plans of action in the world. I think that is of some significance. Yeah, you don't mention it necessarily. I would ask you to think in terms of Sustainable Development Goal 16 and its relevance to infrastructure. Because Sustainable Development Goal 16, as you know, is peace, justice, the rule of law, and respect for human rights. Then now finally, on your research agenda, what's your name? Brigitte? No, Stephanie. Stephanie, I think it is in your chapter, you were speaking about the research agenda. And you frame it as one of the issues. Document and analyze whether the main components of the system are in place and how they work. I think this is a noble objective. So to conclude, I would ask you in your further work, please bear in mind your concept of the national human rights systems, and allow me to say so, my concept of national protection systems. Because if you're not protecting human rights, you're not in the business of human rights. I'm done. Thank you.
Thank you very much, Bertrand. And indeed, we'll come to the discussion, and the authors and colleagues will have a possibility also to react to see how far they do actually look into the protection role of those systems indeed. Let me turn to the second commentator, and I'm very happy that Nosy Ramamonjisoa was able to join us. And thank you very much, Nosy, because it was on late notice. She is the former secretary of the Committee on Economic, Social, and Cultural Rights, and now coordinator of the Treaty Body Capacity Building Program. And Nosy, I would be interested also in hearing, as a reaction, obviously, to the presentations that you heard, and the book also, maybe some words additionally to your practical perspective of where you see national stakeholder participation increase with the treaty bodies within the sessions, as you have been working as a secretary, but also with what the capacity building program is now coming along. Thinking indeed of all those many stakeholders that were mentioned before between parliaments, subnational governments, and so on. So the floor is over online again to you. So over to you, Nosy.
Thank you, Felix, and good evening, everyone. I'm actually very pleased to be taking part in this conversation today, and it's an honor to speak after the former acting and deputy high commissioner for human rights. And also congratulations to the authors of the publication, and we at OHHR very welcome a publication like this, because we don't have the capacity to conduct this kind of research. Well, the findings would be very useful in reviewing our work, how we conduct our activities. And also thanks Felix and to the Geneva Academy for organizing the event, and also for collaborating with the treaty bodies and with their secretariats in general. I'll speak from the experience of the Secretariat of Treaty Bodies, but also, as you mentioned, from OHHR's Treaty Body Capacity Building Program. Maybe I'll also mention a little bit about what's happened in the past and what has changed, and how the human rights agenda, or at least the engagement of states with the human rights mechanism, and in particular with the treaty bodies, has changed a lot from the time I joined the Secretariat of Treaty Bodies more than 15 years ago. And from that time, very often reports to treaty bodies were prepared by consultants or by one or two government officials. And I can recall the case of my own country, Madagascar, where two to three consecutive reports to the Committee Against Torture was drafted by the same person in the Ministry of Foreign Affairs, who was also the one who would come to Geneva to present it. And when that person left or was no longer in service, there was no institutional memory left. At the time also, when I joined the treaty bodies, we had the impression that the concluding observations were shelved somewhere immediately after a dialogue, and then retrieved and dusted only 6 or 7 years later when it was time to prepare the next report. And Sebastian mentioned this a little bit earlier. Concluding observation adopted 15 years ago would just mention the deadline of the submission of the following report. And nowadays, virtually every committee includes a paragraph where it recommends that the state disseminate the document widely with reference to parliamentarian, public officials, the judicial authorities. They also recommend the involvement of course, national human rights institutions, civil society, and other stakeholders in the follow-up to recommendations, but also in the process of consultation prior to the submission of the next report. And they also mentioned the inclusion of the recommendations in the national human rights plans. And all of these are part of what we're talking about national human rights system. And these recommendations were, of course, made knowing the importance of a structure to follow up on the outcomes of the mechanisms involving several actors, and on importance of incorporating them in domestic processes, in sectoral planning, and in development programming in certain countries. The follow-up procedures introduced by almost all treaty bodies, where states are asked to provide update on the implementation of a certain number of recommendations within 1 or 2 years, actually follows the same trend of putting into place a system to ensure that they are followed through. And as mentioned by Domenico, in CRPD, the treaty itself with Article 33 prescribes the national process to be put into place for that purpose. Maybe the last comparison I'd make You may recall 15 years ago, a lot of discussions and research focused or were on the domestication of human rights treaties, so on the norms. And nowadays we talk more, and we've moved discussion to the domestic implementation of human rights and the institutional infrastructure needed for it. And I'd say it's fair to say that the introduction of the UPR after 2005, I think, reform of the Human Rights Commission certainly played a role in this. So the UPR not only democratized human rights, but also it institutionalized human rights reporting at the national level. So before the UPR, you would think there were only a few states that were reviewed by treaty bodies or visited by the special procedures that had regular recommendations from the mechanism and regular reporting. Now all states do. We have more states reporting to treaty bodies. And by democratization of human rights, I would also refer to the fact, for instance, that in a training on reporting to the Committee on Economic, Social and Cultural Rights, you'd have representatives of ministries such as social affairs, social protection, environment, but also representatives of statistical offices and fiscal authorities, because they would look at the obligation to invest the maximum available resources. And the same actor would have to meet again at the time of the briefing of a review and discuss the recommendations and how to implement them. So it certainly need an institutional framework, if not a robust one, for these kinds of actors to work together on human rights project. Maybe by democratization also, and you asked the question, Felix, 10 years ago, or 10 years ago, when I worked with the Committee on Economic, Social and Cultural Rights for the first time, we would have maybe 5, 6 NGOs engaging with the committee at a given session. And right now, at a session, they would receive maybe more than 100 submissions. So they would engage with as many stakeholders, so civil society organizations, actually, but also academics. The committee would receive submissions from academics, from UN agencies, from non-traditional actors, including actually from companies, from businesses. In the case of, I think it was the review of Australia. So there was really this diversification of actors that interact with the treaty bodies. So maybe turning to the program. So even the creation of the program in 2015 came as a result of the treaty body strengthening process. I think the state's experience with UPR did play a part in it. The program itself was established by a General Assembly resolution, so it was at the initiative of states. And at the program, at the outset, we already dedicated effort in assisting states in setting up or strengthening national system for reporting or implementation of recommendations, what we call national mechanism for reporting and follow-up, and MRFs. And within a year of the creation of the program, we already published this guide on an MRF, and that guide pointed to the need for a comprehensive and sustainable approaches to reporting, engagement, and follow-up mechanisms. So supporting state in setting up or strengthening this mechanism is still and remains and is a core activity of program and our field presences. And just given how intertwined human rights and SDGs are, we're also working with UNDP on projects in several countries supporting strategic engagement of states with the human rights mechanism, but specifically with a view to achieving the SDGs. And in these activities, we engage with NHRIs, civil society organization, but also with non-traditional actors, such as SDG focal points and what parliamentarians, but I think they engage more and more with the mechanism, and they're more and more involved in human rights conversations. And maybe if I may close my my contribution by referring to an information management product actually that we're offering to national mechanisms, which is the NRTD, the National recommendations tracking database. So it's a tool that offered to states to manage the hundreds of recommendations from human rights mechanisms, but also to support the continuous collection of information from various line ministries, for example. So it's very much built to support NMRFs in their function of engagement with treaty bodies, but also with their treaties or human rights obligations in general. So we've designed the product having in mind the multiplicity of actors at the national level. So we have developed functionalities that facilitate the preparation of reports, but we also include functionality to track the implementation, so that these recommendations lead to concrete results and impact and may contribute to what we talked today about a goals-based approach. And finally, the tool would have a public interface, and we think that that could contribute to the national systems of transparency and accountability. So thank you. Felix, I don't know if I've responded or given information that you've responded or to your questions, but I'd be happy to add more if necessary. Thank you.
Thank you very much. No, indeed, you answered the questions and you went beyond, and I'm very interested also in maybe following up to that when I hear that there should be a public interface to the tracking database, which indeed will be very interesting, not only for academics, but for very practical purposes. So looking forward to that discussion. With this, let me open the floor actually to all of you here in the room and online. As mentioned before, if you're online, you can send questions through the chat, and I see that some questions have already come in. So I invite also Stephanie, I see there is a question for you. I invite you to see those questions, and I'll take all kind of comments and questions here from the floor. We have a little bit more than 20 minutes left before the end of this event. So with this, I'm throwing open the floor to any of you, and if you're online, you can raise your electronic hand, or you can just type also in the chat if you want to take the floor. We're monitoring that. So turning first to the room, yes, Milun, please, Milun Kotari.
Good evening, and thanks very much for the invitation to everyone. It's very interesting. I haven't read the book, so I'm just going to ask a couple of questions. One very important actor that was not really mentioned was civil society. I'm just wondering, where civil society fits in, because if you look, let's say, at the example or the experience of many years of work on the Universal Periodic Review, we have now these national alliances of civil society organizations that are playing a very important role. And the question that comes is that not also a form of domestic institutionalization, because they are playing a very important role in that. The second question I had was more on, one of the weaknesses in the human rights system is, I think somebody mentioned that you go from report to report and nothing happens in between. And so this work that is going on monitoring implementation of recommendations from the national system, where does that fit into what you're all doing? Because it's not only a question of monitoring implementation, but also a question of tracking what happens, whether there is change on the ground, and does it then lead to to the realization of rights, but also to the accountability of actors that are violating the rights, which very often is the state. I think that's what he was referring to earlier. So that gap that is there, and in that context, let's say the midterm reporting process of the UPR has played a very important role, and now there's this reform of the treaty bodies and thinking. And finally, the point I wanted to make was, it may be incendiary in a sense, but I think Bertie, this refers to something that you said.
Was I being incendiary?
No. Is democracy necessary for the domestic implementation of human rights? I think we've learned again through the UPR process that even in difficult countries which we might not consider democratic, there has been progress. And then, of course, there's a fifth question that those countries that we do consider democratic, are they really democracies? So, I mean, there's a whole area there that needs to be explored. But thanks very much.
Thank you. And we add to your three other questions, and also whether democratic countries necessarily are always implementing human rights. So another seminar for us to hold here, but more questions. I'm seeing there's a question coming in, and also ask her if you would like to take the floor and state your question yourself. Otherwise, I'll read it out later. So other questions maybe here in the room also. Anyone else? So we're collecting. Yes, please.
So I have two questions specifically. So one stems from my background work with national human rights institutions. So this idea which has been proposed by the first speaker about systemic approaches and the standardization process, how is it fair in the context of cultural relativism, which is always a challenge in terms of implementation of human rights? Could it instead be a tailored approach towards implementation of human rights? And secondly, that's something which comes from Mr. Ramcharan's point on the recent Freedom House report, which showcases that democracies are different. So when in countries when governments change, at that juncture, how can NHR rights still go about with the implementation of human rights or the institutionalization of human rights, despite the change in the government mechanisms? Although again, I have not read the book, but I thought maybe I would solicit some views from you.
Thank you very much. So I'm turning to the online audience and ask Kierum if you'd like to take the floor. Over to you.
Good afternoon, everyone. My name is Asger Kierum from the IRCT. First of all, really thank you for such an amazing event. It's truly incredible when somebody sits down and really, shows the panorama of what is going on with human rights in the world for you, because most of us don't always have the time to do that. So really thanks a lot. And I think what has been described here today, it's really testimony to how, as Domenico put it, like human rights is everywhere, right? It's business, it's civil society, it's parliaments, and I think it's certainly not dead, as some people like to say. So I think that's really amazing. One thing I wonder, and whether you have been looking at that, is that at least from the civil society perspective, we often benefit from the space of things not being entirely fully regulated, and these things maybe not being a system as much as a number of different systems, or even like a human activity organism that is acting together. So we often benefit from that, but of course we also benefit from predictability and all these other things. So I wonder if you had been looking at where do we draw the line? What will be, how much do we risk losing in innovation if we over systematize or regulate these areas, and vice versa? How much do we lose in efficiency and effectiveness and implementation if we don't? So that's something that we are grappling with and speculating, both at the national level, but of course also at the interaction between national and international and so on. I know that was not a very easy question, but it's certainly something that we're really thinking hard about. Thanks a lot for this space.
Thank you very much, and I'd be disappointed if you were just asking easy questions, so thank you very much for that. I see a question by Arthur also on the chat, so if you'd like to take the floor directly and pose it, also inviting you to take the floor, Arthur. Otherwise, for the moment, I don't see requests from the floor online. So again, to the room here, if anybody else wanted to ask a question or do a comment, because I think we will not have time for 2 rounds. So actually, let me just get all your input now before I hand it back to the speakers and commentators. Yes, please.
The question I have was on the NHRI is the extent to which NHRIs evaluate themselves, and to what extent do they evaluate the projects or the recommendations that you do, what extent is it actually implemented? Is there an evaluation of this?
Thank you very much. Further comments or questions before I give it back to the speakers? So I don't see any in the room, and so didn't hear from Arthur, so let me just like pick up the question that she posted in the chat. The question specifically addressed to Stephanie, but maybe also to the others, about the role of state actors. And he says, in this regard, I would like to ask about local authorities and their role in the implementation of human rights recommendations. Did you consider their role, especially in the context of widespread decentralization movement? So I'm adding that also to the list for our speakers. And with this, would like to give it back. And if you allow me, start again, Stephanie, with you, and give the floor to you for reactions.
Yes, thank you very much. Just want to make sure. Yes, it's okay. Everything is working. Yes, thank you very much for the question. I just want to say as a little caveat that I couldn't hear so well the question from the audience in Villa Monnier. So yeah. But I think, I mean, there's a lot of questions that are very different in types of question, and also thank you, Bertrand and Nosy for the comments. What I'm prompt to say now is that I don't think our book is promoting a model in any way. So our book is more looking into and I would say observing a trend at the level of the UN and also other international organizations, and is trying to critically analyze it to try to find out, okay, what does this do to human rights protection at the domestic level? And from mixing the national human rights system approach and the domestic institutionalization approach is really to try to remind us to be to try to remind us exactly what you said, Bertrand, to look at implementation of human rights at domestic level, at protection, what is actually going on the ground. So I think part of our approach is actually a bit critical also of this promotion of, you know, institutions and building, I mean, building stronger institutions. It's a very nice thing, the SDG 16, there's no doubt about that. But what is interesting for us is, in fact, what does it mean on the ground? What does it mean for these institutions, for the processes on the ground? And then also, when does it get to actual protection of human rights? So I really think there's no, for me, it's very important to say that we're not promoting anything. We're just looking into how exactly this diversity of actors, which are not only, you know, a few actors, but are also local actors, are traditional human rights protection actors, new governance actors, how all this multitude of actors is interplaying in a multitude of processes. And here I really think to relate to the question from Aska, there's really a huge room for all kinds of processes. So it's not about putting things in a straitjacket at all. It's just to try to understand what it is that is being prescribed now, and what does it do? What does it do in practice? So yeah. So for me, it's one important. It's really the critical dimension is actually quite important, and in the book, as I mentioned, you know, the article on parliamentary committee also. It's what is promoted right now, and it has some advantages, but it creates also other kind of new problems to create a new actor at the domestic level. And some of our concerns are also exactly about this straitjacket thinking that I think you're thinking a bit about in your question. I mean, are we then channeling resources towards some specific type of mechanism, towards, you know, governance mechanism, getting a bit away from this protection goal that Bertrand is talking about? Because at the end of the day, I mean, that's the protection that is the goal. Promotion also, but protection is the goal. So I really, maybe I didn't say it clearly enough in the introduction, but the book is not promoting a model. The book is observing something that is going on and trying to dig into specific case study of how it plays out in practice. But that's also why we think, I mean, that's also why we are really calling for, research on specific actors. That's what we've been trying to do with this work on governmental human rights focal points. It has become quite a privileged partner of the international human rights mechanism, that we should work with governmental actors within the state. And I mean, what does it mean in practice to do that? I mean, what are these actors able to do in context? So yeah, so I think it's the main point I want to make now. And for me, yeah, just maybe to bounce back on what Domenico was saying about, having guidelines and so on. I mean, I see them as an interesting add-up to what is going on if they focus to a large extent of what is going on at domestic level, on what if they focus on how you can have some general principles for interactions, processes, respecting the variety of context, but also, as it was said, the variety of small processes going on. So I think I'll stop here for now because I can see there's not so much time.
Thank you very much, Stephanie, and over to Sebastian for your reactions also to the comments and questions. I don't know if they were directly addressed to the CRPD situation, but definitely so just also to recall the questions that came in here in the room, where civil society fits in, how do you track change on the ground, and also to see about democracy as a necessary prerequisite for domestic implementation. Over to you.
A lot of very interesting questions. I'm not sure I will touch about all of them, but very quickly, I would like to comment on some of them. Just I think the discussion about which qualification you put within national human rights system, whether it's protection or something else, is very important, and it's something that Stephanie just touched upon. We try to understand what is also the intention when regional or international organizations are producing guidance. Sometimes it's in order to build better transmission belts at the national level, and sometimes, as you mentioned, Domenico, the Belgrade principles, which are horizontally between the actors. Sometimes the guidance is made in a way that is building a system that nationally would work, which work better without having this necessarily being transmission belt of the international actors. So there's this element of intention is very much in our mind when we review the different guidance. And I would say that it started mostly about protection, including redress, looking at the courts and so on. It's moved on maybe with the CRPD to implementation, trying to make sure that you don't need to reach the level of protection and redress, but actually have proactive mechanisms in place so that you would trigger a positive change. And more recently in the Human Rights Council resolutions, we find the sentence phrase national human rights follow-up system, which is very much about looking at the part of the system which is implementing, I think it has also read national human rights statistical system. So you have all these that coexist, but it's interesting to see what's the intention and what exactly you're trying to promote for the guidance and how this fits all together. And definitely, as Stephen said, we're not promoting one or the other, we're trying to observe these trends. On civil society and also local authorities, a little bit on the genesis of the project and how a research project works. On the genesis, we had an interest in looking at what we thought was lacking a little bit in terms of scholarship, but also we had an interest in being self-critical, because as you know, the Danish Institute for Human Rights is the HRI of Denmark, but it's also active around the world in doing capacity building and projects. And we wanted to be wiser about our assumption that if you build better system, then you will implement rights. And looking at what are the cornerstones of these systems, which are more the state actors. So it does not say that civil society is not important. It's very much as part of our concept, but it was not part of this specific project for these reasons. On the contrary, local authorities were. It was part of the first draft, but it's not in this book, but it was part project initially. Then to ask her on, I very much sympathize with the idea that, yes, you have all these recommendations coming from different places. So if the state wants to, and they're all aimed at simplifying the state's activities, the NMRFs are very much going in that direction. But if you compare them with the recommendations from treaty bodies, for example, the CRPD will never recommend a National Human Rights Action Plan or an MRF. It would look at what's the best fit for the purpose of implementing the convention. And so it has recommended multiple national action plans on LGBT rights, multiple action plans on specific rights. So all this, if a state would do everything that comes up from different angles, also from regional organizations, that will definitely be not rationalizing, but in fact, creating many processes that states should engage in. And I think what is very clear in the approach that the OHCHR has been taking with the NMRFs, for example, is to always recall that it's not a one-size-fits-all approach, but more that you should look at it as a panoply of things that could be done and contextualize it and pay attention to what is actually working in your country. And I would add that, yes, there's an element of looking at the institutions, and we looked at state actors, but there are other type of actors, and there's a chapter on that in the book on business, for example, which says that maybe we can also not talk about systems because it has these rational aspects, but talk about spaces. So with different levels of engagement, and I think that's
thanks. We're running out of time. Sorry, but I want to give the opportunity to Domenico, but also to the commentators if they want to close with a word. There was also the questions how NHRIs evaluate impact. So maybe your chapter was on NHRIs. If you would like to address that one.
Yes,
then we'll need to come to a close.
Of course, and I'm aware that we're running out of time. Before we get on the NHRIs, I think an answer to a number of questions that related to whether we're over systematizing through this concept of national human rights system, and also how to monitor change in between reporting, the aspect of cultural relativism. So there is a difference, right, in between mandate-based and context-based approaches to the study of national human rights actors. And in a way, the concept of national human rights system, and for that, I invite you to read the introduction to the book. If there is one chapter to read, I think that is very much the one that really portrays the idea that we're trying to bring forward, is an answer, because there is a tripartite distinction between actors, interactions, and frameworks that Stephanie and Sebastian and Jensen describe, that in a way utilizes the concept of a common denominator approach to the different institutionalization processes that can take place from one country to the other. So we're stepping, one step above the contextual approaches that then are being treated in the different chapters. So in a way, this is a research agenda that wishes to bring together, well, the authors that are now part of the book, but of course, there's many different colleagues.
On with it.
Hello. Okay, well, yes, and in this case, the idea is really that of trying to portray a sort of common denominator approach to the various contexts that can be taking place. I think that the NHRI question maybe we can take later on during the drinks. Yes.
Thank you very much. We have Nosy raised her hand, so just a comment also again from you, and then we'll give the closing word to Bertrand, the closing of the meeting. So Nosy, over to you.
Thank you, Felix. I would just like to make one comment on the question on monitoring of compliance, whose role it is. I think the treaty bodies are also called sometimes treaty monitoring bodies, and they make an assessment on whether there's violations or not. They make recommendations with their authoritative interpretation of treaty provisions. They have, I think, a certain advisory role also, but I think there's only so much that the treaty body or committee meeting a few times a year in Geneva can do. So the monitoring of treaty obligations should take place primarily at the national level. And I think, and that ownership at the national level should happen. And I think the recent instruments, the international instrument that were adopted in the past years, I think had this in their provisions with CRPD, but also with OPCAT's National Preventive Mechanism. So we hope that a tool that we develop like the NRTD can contribute to this monitoring at the national level. A country is reviewed by a treaty body only according to certain periodicity, but a tool like this would provide information on implementation of recommendation continuously, and information that's accessible to the public. And I think we agree it's certainly an ambitious goal, but I think a tool also can bring about change. And we're still at the conceptual phase of that module or interface of the NRTD, and we hope to develop the functionalities on the basis of the insights that we received today in this discussion. Thank you.
Thank you very much, Nosy. And with this, and with apologies to those who just still send in questions in the chat that we don't have the time, unfortunately, to address anymore, I will give the closing remarks to Bertrand Ramcharan. So over to you, Bertrand.
I would just address 2 points. First of all, on Melanie, your question on democracy and the question on cultural relativism. My point was that when we are analyzing or we're taking stock of what is taking place, when I studied law, there is a maximum of equity that says he who comes to equity must come with clean hands. And quite clear, some of these undemocratic countries are not coming with clean hands. And I'll stop there, we don't have much time. And to the authors of the books, I just want to say this. I endorsed your concept of the national human rights system. I did not think that you were advocating any particular system. In my case, when I drafted what went into Action Plan 2, I think it was, of Secretary General Allen's reform report, where we put the idea of the national protection system. Let's say the human rights practitioner has to make choices. And I chose to frame this in terms of a national human rights protection system for 2 reasons. One, I wanted to promote within countries and internationally an understanding of the idea that every country ought to have in place a national protection system. And that's why I defined it with the 6 elements. And secondly, the plan of Secretary General Allen, as we wrote it, invited all agencies of the United Nations system to contribute to the establishment and maintenance of a national human rights protection system within each country. And I would end, I've been of the view for quite a long time, I mentioned to you on an informal basis, that there should be some place, a world report on national protection systems. Voila.
Thank you very much on that closing note. And with this, we take a leave from you all online. I would like to thank the Danish Institute for Human Rights for partnering. I would like to thank the speakers and commentators in the room and online, and same to the participants in the room and online for your interest in this meeting. For those who are with us here in the room, I'd like to also invite you to have a drink with us just next door. So this is the advantage of coming to the meeting also over being online. But to those online, I'd like to encourage you to join in again for the next human rights conversation, and also to join in person or online for the annual conference of the Geneva Human Rights Platform, which will look at the connectivity between national actors, national systems, and the international system. With this, thank you very much. Have a nice evening, afternoon, morning, wherever you are. And thank you again very much for your participation.